Good evening, ladies and gentlemen. It's an honor to be here. Hopefully when you go home tonight, you'll walk out of this meeting after hearing the preceding speakers justifiably alarmed about what you've heard. You heard my colleague and good friend Judge John Russo mention he was asked to be by the Chief Justice who created this task force, Chief Justice Maureen O'Connor, to be on the committee, and I have to concede that when I found that out, I was a little bit jealous of my friend, because the death penalty had been something that I had been very interested in Cuyahoga County for a lot of many years. I started my career as a prosecutor, and I have to concede that as a prosecutor, when I was a prosecutor, I did not see any problem with the death penalty. After hearing scenarios of crimes, I thought I had reached my zenith in being able to be shocked by man's ability to act in such a depraved manner when they take another man's life. But then every time I heard what I thought would be my limitation, along would come another crime that would shock me to the core. So my perspective changed, however, when I was elected judge in 2005, and during my first year in office, I had the opportunity where I was faced with the possibility that I would be delivering a sentence for the death penalty. And this trial occurred in 2005 when both Judge John and I took office. It was originally set for February, less than 30 days after my swearing in. Fortunately, it was moved into October with the agreement of the party, and I was able to take a course down with the Supreme Court specifically designed to teach judges how to handle death penalty cases. When I took office, there was a practice that was not uncommon in, Director Collins alluded to it, death penalty charges were not uncommon. In fact, it wasn't an uncommon situation to be a judge on a court of 34 judges in Cuyahoga County and have multiple death penalty cases on your docket. And at one point we put a limitation that you can only have 2 at one time because of the amount of work that went into them. But there was always, as Director Collins mentioned, not an uncommon practice of shortly before trial, the state of Ohio, as part of its plea agreement, removing the death penalty specifications in exchange for a plea. That's what my bailiff, who had 8 years of experience with another judge, thought would happen with this particular case on my docket. And we set the trial in October. I cleared my schedule to make sure that this case would go forward. I told the parties on the record that it was the most important case on the docket due to the severity of what was at stake. The case proceeded to trial as scheduled in October, and I didn't know much about the facts of the case until the case unraveled, but it turned out what my bailiff's prediction that this would be a robbery gone bad, not a severe set of facts, turned out not to be the case at all. In fact, the facts were horrible. They involved a young man, the victim in the case, had spent the day putting new spinners on his car, the kind young kids like to put on and drive around, and he was very proud of it. His father had helped him all day. And he went driving down to the city of Akron from Cuyahoga County to show off his car to some of his friends. He went to a nightclub, and unfortunately he ran into a friend who was with 2 known criminals, and they quickly saw the car and they wanted it for themselves and decided they were going to rob this young man of the car. Then the 2 criminals with long criminal records realized that the third individual knew this individual and knew that if they took the car, they might be able to get prosecuted. So what they decided to do, that this young man had to die. They put him in the trunk of the car, drove him from Akron to a deserted field, East 83rd and Rawlings. I still remember these facts. And the defendant in my case opened up the trunk of the car. As the young man pled for his life, he unloaded 7 bullets into the victim's stomach. They pulled him from the car. He was still alive, and he was pleading for his life. He was still obviously screaming and in pain. And another defendant in the case proceeded to use a hammer to end the case. When the state was done with their case, in death penalty cases, you have a guilt phase, and then you have a mitigation phase in which they decide whether the death penalty should be recommended. And in the other colleagues' room, for whatever reason, they offered that defendant who used a hammer in the killing a plea bargain of 45 to life, an actual opportunity for parole at some point, albeit somewhere later long in his life. But the defendant in my particular case refused to enter any type of plea bargain. The judge accepted the plea. That person was sentenced right away to 45 to life. And then the mitigation phase came in January. And I saw this issue coming a mile down the road, but the prosecutors placed on my desk on the day of the mitigation phase a motion in limine to keep out the fact from this jury that they were going to ask the death penalty in favor of. They wanted to keep out the fact that they had pled the other individual out. They stated there was no reason that they stated why the plea bargain was entered. He had not cooperated in the prosecution in my case. They just said that was their prerogative, and they asked that they kept it out. So the case law at the time was very unclear on whether that was warranted as a mitigating factor to come in, and I was so glad to have had that training, because I immersed myself. I talked to other judges, and it just struck me as unfair that the prosecution should be able to go before a jury, ask them to put someone to death, and not tell them that someone that was equally, if not more heinously culpable, had been spared just by the whim of a supervisor who marked the file. And so I ruled against the state of Ohio, and the defense lawyers were allowed to bring that fact in, and the jury recommended a sentence of life without parole. And he was sent to prison. I remember talking to the victim's father after, and you know what they say about people that the death penalty, I can say for sure, from dealing and talking with these victims, it provides no solace. This is something that they live solace. This is something that they live with the rest of their lives, and the death penalty does nothing to temper that. And he was satisfied that justice had been done, and he was sentenced. So this whole experience bothered me. I started gathering statistics about Cuyahoga County in particular, because I learned that over a 10-year period in Cuyahoga County, there had been close to 380 indictments, which doubled Franklin County, almost tripled Hamilton County. It was the greatest amount of death penalty indictments in the state of Ohio. So I wanted to see what happened to all these cases. In 380 cases over a 10-year period, the state of Ohio looked at the facts of a case and said, this person deserves to die. We are going to pursue the death penalty. Well, an amazing thing happened when I got all the statistics to find out what the resolution. I found out of 380 death penalty prosecutions, do you know how many resulted in a death penalty verdict by a jury? 4. 4 out of 380. So I said, what happened in the other 380? So then I looked at the dispositions. And sure enough, as Director Collins mentioned, in the great majority of those cases, the case would come up to trial. They'd say, we'll take the death penalty off the table in exchange for your plea of guilty. And I thought, well, are they getting good results as a result of this? Are they getting sentences that are going to protect society? And the results amazed me. Some cases that started out as death penalty cases ended up in pleas to 10 years, 4 years, 5 years. Judge Russo even had a death penalty case that was initiated as a death penalty, and ended up in the defendants getting probation, if you can believe it or not. That's the truth. And in Cuyahoga County, we had a number of death penalty cases which at the guilt phase, after the guilt phase, the defendant was found not guilty. He went home for lunch after someone that the state had looked at the case, the facts, and said, this person deserves to die. And then he was found not guilty. That didn't even make the papers in Cuyahoga County. That's how common it was. If that happened in a rural county, you'd think that they'd say, wait a minute, what's going on here? You proceeded, you spent all this money to pursue the death penalty, and the person was found not guilty? Didn't even make page 1. So I have these statistics, and I petitioned Chief Justice O'Connor to be on this committee. I'm very grateful that she did. She allowed me to go down, and it was a great experience. I served on the Judicial Roll Committee, and that was chaired by Judge John Sullivan from Belmont County, just a judge's judge. Also, Judge Roger Wilson was on that. Two senior judges that I think are both beacons of fairness. And we tried to examine what could be done if there's going to be a death penalty to make things better. And I'm very proud of the recommendations that came from that particular committee, and I think they should be passed today. I mean, there shouldn't be even any debate about it. And number one is that if there's going to be a death penalty case and the state's going to pursue it, there should be total, absolute transparency in that case. And what I mean by that is there's no talking in chambers without a court reporter there. Every single stage of that case should be on the record in open court where the public can watch it. And there's a court reporter taking everything down. There's a reason for that, because when people get put on the record, they don't want to lie. They don't want to misrepresent. If we had this rule in effect now, and these are generally regarded as the best practices, talk to the most senior judges that have tried a lot of death penalty cases. They'll say, I do this as a matter of course. It should be mandatory. Prosecutors should be made to stand up on the record and say, Mr. Prosecutor, Madam Prosecutor, are you representing that you have turned over every piece of exculpatory evidence to the defense? That way they have to say yes. If it's proven later that they're lying, they lose their license to practice law. Attorneys don't want to do that, but putting it on the record will make that happen. Likewise, defense counsel, whether they're competent to be representing these individuals, judges can make inquiry on the record. What have you done to prepare your case? So that's one something that should be passed today, right now. That's one recommendation. That is not in effect. Another one involves defense counsel's ability to pursue defenses without fear that they're tipping their hands or inadvertently making the state's case stronger against their client. And we came up with a mechanism that if passed, they would be able to go before the trial court judge in an ex parte hearing without the prosecutor there, on the record, and ask for funds to be expended for certain types of experts, without at that point revealing who and why they're doing this, because they may be exploring methods of defense that they don't want to tip their hand at that point to. And it might result in information that is actually helpful to the state, so they don't want that to go into the state's hands. This way, the judge can hear that if it's reasonable, the judge can grant it. And we've also provided an important safeguard if the judge denies it. And a lot of the defense attorneys have this fear that judges, based on monetary reasons, would deny it. You can take that immediately across the street or wherever your court of appeals is, and we call it across the street in Cuyahoga County, and you can address that issue where the court of appeals can say, no, you grant those funds, this is necessary. And it's sealed, and the prosecution doesn't know about it. So very important safeguards that I think are in the interest of justice. So I urge you to read the report. I think that a lot of the recommendations, my biggest fear was that this was going to be thrown in some, this task force report would be thrown in some bin and it wouldn't have the attention that you're giving it to tonight. But I remember with being in the car after the first meeting with Judge Russo and commenting to him and saying, you know, Chief Justice O'Connor has done a great public service in creating this task force. And I'm sure there's going to be great recommendations that come out of this task force. But the biggest, most important accomplishment in my mind that the task force completed is to get people like you in this room interested so that you can see what we examined over a 2-year period and see exactly how the death penalty is applied in the state of Ohio. You would think that the proponents of a death penalty statute would assume that the most severe punishment should be reserved to the worst, for the worst of the worst. You would assume that the proponents of capital punishment believe that a law on the books that allows for it to be applied equally, no matter where you are, where you commit these heinous crimes. As Director Collins mentioned, that's not the case. And that can be proven. That's not my opinion. I can prove that. You know, as judges, we don't go out and we say, I'm not saying my position, my personal position against the death penalty for it. We don't talk about, we take an oath to follow the law that exists. And that's what we do as judges. But we're also on the front lines. And when we see things that can be proven that are completely unfair, I believe you, the citizens, have a right to know that and decide, is that what the state you want to live in, where that unfairness, that inherent unfairness that takes place. You heard very moving from Mr. Jameson, who John told me, based on his conversation before his speech tonight, he walked in, an innocent man, on October 25th and walked out 20 minutes later, or 20 years later, after being found innocent. That should be very alarming. We had a discussion during the task force. I don't think we gave an hour to it when the state of Ohio shot it down and it was not even proposed again. We thought, hey, if we're going to be pursuing the death penalty, maybe we should raise the standard of proof, that we should tell jurors before they make that decision on whether the death penalty should be warranted, maybe they should be convinced beyond all doubt. What's wrong with saying that? And the state immediately, that's an impossible standard. We're against it. But shouldn't a jury, if you're going to be making that recommendation after they hear the evidence, I mean, what's wrong with being convinced beyond all doubt in your head? This was thrown right out, and the fact that we have so many exonerees should be very alarming to everyone. So these are the facts that need to be brought out, and I thank the organizers of this event. These are facts. Check them out, and if you're sufficiently moved, I think you should be after hearing the previous speakers, go out, tell your friends, and let them know this is how the death penalty is applied in the state of Ohio. Thank you.